Right, we'll talk about insolvency tips and traps. The rubber really hits the road with PPS when one of our customers goes into liquidation. That's the big risk that we're all worried about. So, a bit of a show of hands, who's ever dealt with a liquidator when one of your customers has become insolvent? Okay, big show of hands. Keep your hand up if you enjoyed the experience. Righto. The reason we don't enjoy the experience is because insolvency laws are an absolute minefield. When you add PPS on top of that, we double the situation and we double the pain. So if we can successfully navigate our way through that minefield, we can come up trumps and we can have some money in our pockets. But if we slip up on a technicality, it's all lost pretty quickly. One practical example here is with proofs of debt and how proofs of debt are being applied. Anyone ever seen one of these? Show of hands, this is a proof of debt form. You ever seen one? Okay, keep your hands up if you knew that by completing it incorrectly, you're giving up your PPS rights. Okay. What we need to remember there is proofs of debt, the reason we're completing them is because we need to let the liquidator know the amount of the unsecured debts. Liquidator's job is to take the money, the assets that's there, turn it into cash, put it into a tin, and then pay it to the unsecured creditors. By completing a proof of debt, what I'm doing is saying to the liquidator, hey, excuse me, sir, madam, I'm an unsecured creditor, can I have my 2 cents in the dollar, please? If I'm a secured creditor and I complete the form, and if I don't estimate the value of my security, what I'm saying to the liquidator is, treat me like an unsecured creditor, I'm going to give my security to the greater good, to your fees. So what we need to do is make sure, one, we see a proof of debt, a little red flag comes up, the siren starts flashing and we remember that there's a big risk here. And then what we want to do is look at this part that says, this is where I estimate the value of my security. Most instances, the liquidator doesn't pay a dividend for a couple of years anyway. So what's the big rush? Why do we rush to get our proofs of debt in there? So long as the liquidator is aware of our claim, and if we think we've got an ROT right, maybe we're better off making sure the liquidator is aware of our claim, gives us notice before they go and adjudicate on proofs, but see if we can get our goods in first. And then we'll know what we're an unsecured creditor for, and then we can lodge a proof of debt. You can alternately just estimate the value of your security. That does trigger some processes in the Corporations Act, but they're generally fairly harmless. Or if you're in doubt, just put your hand up, give someone that knows what they're doing a bell, and if you're a client of ours, you'd already be doing this. If you're an NCI client, feel free to call us and spend 2 or 3 minutes on the phone. We'll be able to tell you whether it's what to do and how to deal with it. So if I'm an ROT creditor, I'm a higher or a lesser, I'm not just going to go completing my proof of debt because it might give up my rights.